Hey, welcome back. So what happens when you do it live? We had technical difficulties, so we lost signal there for a second, so we're back. So you're watching Real Estate Talk Live here on location at Arcia Law Firm. We're talking about FERPTA and what are the ramifications, what is it, what it doesn't do, what you have to do. So we last left off, I was about to ask you to go back to the very beginning. What exactly denotes somebody being a foreign national? What is the difference between someone being a foreign national and FERPTA applying to them and everybody else?
Right. I mean, as far as FERPTA is concerned, anyone that's residing outside of the United States, someone who doesn't have a social security number, I mean, someone who's, and the best way to deal with that from the buyer standpoint is to just get a certificate of non-residency. So if there's any question, you could say, oh, the person, what usually, I'll just put it to you this way. What ends up happening 90% of the time is you have a seller that says, yeah, I live in Europe, but I'm at this house, 30, 40% of the time, 50% of the time. And we don't know, as a buyer or the buyer's agent, you can't confirm or deny that. So the only way that you can get confirmation on whether or not this person resides in the United States or not is to get a certificate of non-residency. So if the person gives you a certificate of non-resident status, then you know they're a foreign national. And if they give you the necessary notification, it has to be something under oath and under penalty of perjury. None of this letter, sending you a letter saying, oh, by the way, I live in the States most of the time, so I'm not really a non-resident, and FERPTA doesn't apply to me. As a buyer and a buyer's agent, there are ways that you can ensure that doesn't happen. That you don't get tricked into thinking that that person lives or is a foreign national.
So the agent taking the listing, at the time that we're taking the listing and we're explaining aspects of the agreement, and we get to the section as to whether FERPTA applies to them or not, the safest, easiest way to do it is say, listen, would this section apply to you? Are you considered a foreign national? And they say, well, what does that mean?
Because where do you live? Where do you live most of the time? Okay. And if they say, well, I live most of the time in Florida, well, then no problem. You can give me a certification of non-foreign status, and you can sign that under oath and under penalty of perjury, right?
Right.
Sure. And then once you got that, then as the buyer, you're in the clear. You don't have to worry about doing the holdback, because now they've certified under oath that they're non-foreign, that they actually live in the U.S. So this FERPTA wouldn't apply to them.
Okay.
But now, if you get some pushback on that person wanting to sign a certificate of non-foreign status, then that should be a red flag to you that there's something more that needs to be looked at. For those of you out there, I think it's important for you to reread paragraph 10I in the FAR as is 5 contract, and then also read standards 18V. That's in the FAR contract as well, for an explanation and a deeper explanation of what's considered applicable under the FERPTA statute. Now, I want to just kind of go through a couple of issues that I see coming up all the time with these kind of cases, and just kind of to go through some of the responsibility that the buyer is going to have and how you can address that responsibility. I hate using the word get around that responsibility, right?
No, you don't want to get around.
I like using how to address that responsibility. And just to remind brokers and to remind realtors that you guys have some very real exposure here, and unless you address it properly, you're going to be looking at a potential negligence claim. Okay. Now, in every case, and this was a tricky issue, because we talked about this within the context of even within a short sale. Okay, yes. Even within a short sale, FERPTA would apply, because the language that's used in the contract is not what the seller nets from the transaction. It's what the seller realizes from the transaction, and realizes is read by the IRS very broadly. Okay, they don't realizing doesn't mean what you net from the transaction. It's what you actually make in the transaction. Whatever the gross purchase price is, you're going to pay.
The sales price itself is the figure that's used.
You use 15% of that gross sales price. So
Gotcha.
I want to make sure that at the outset everyone understands that that's the number we're looking at,
Okay.
and that's a potential exposure you want to get around. Now, exceptions to FIRPTA. The easiest exception is what we talked about earlier. If you get a non-foreign certification, a certificate under oath from someone who is claiming to be a U.S. citizen or resident alien, you don't have to worry about FIRPTA. Okay, you're good. The other thing is you have someone who says, I do live outside the United States, but I live most of the time in the U.S.
Okay.
And we have to do something called a substantial presence test. Okay? Under the substantial presence test, the magic number is 183.
Okay.
If you can prove that during the last 3 years you have resided in the U.S. For a total of 183 days at least, then you would qualify under the substantial presence test. But it's a very complicated calculation because the last year you look at one set of numbers, and the previous year you look at another set of numbers. This is something that needs to be done by the title company. But just know that there's a way to address the FIRPTA issues if you're a foreign national, if you reside in the U.S. for a certain period of time. The other way to deal with it is with the WC, with a withholding certificate. And with a withholding certificate, the seller may be entitled to reduce his or her FIRPTA liability to 10%, or it could be reduced to 0. The drawback of getting that withholding certificate is it's a process. It requires you to file a mini tax return. It's about $1,000 process. You need to hire a CPA, get an ITIN number, get basically the equivalent of a Social Security number for foreign nationals, and file a mini tax return showing that you would actually take a loss on this particular transaction, and therefore you wouldn't have any tax liability and wouldn't have to pay that 15%.
So that could apply in the case of a short sale.
That may apply in the case of a short sale,
Okay.
but you would still have to get that WC, that withholding certificate. And that's what may tie up the transaction. See, short sales, they want to close them very quick.
Right.
It may take you 45 to 90 days to get the withholding certificate from the IRS.
So they could not start that prior to getting the short sale approval and have that going kind of parallel to the approval, or you have to wait to get the approval and have a HUD and all that to show them first?
You could certainly start it before the short sale approval. The obstacle you're going to come across is the fact that some people are going to have to come out of pocket here.
Yeah, for the fees associated with getting that done.
Right.
For someone that's in a distressed situation, they may not have those funds.
Right, so who's going to come out of pocket here? Number one, the lender. The lender's already taken a huge hit.
Right.
Right? They're taking a lot less money than what they're entitled to under the
Okay.
mortgage. So they're going to be very reluctant to put up that $1,000.
Sure.
Taking $1,000 off the net. So who else? Well, the seller is going to be. You're asking the seller now to come up with $1,000, and they're already saying, I'm getting rid of this property because I don't want it. I don't want any responsibility for it. Now you're asking me to pay an additional $1,000. So then it goes down trickles down to the agents. Okay, so the agents now can say, okay, well, we want this deal to go forward because it's a good enough deal.
Right.
So maybe we might want to put up each of us put up part of that $1,000 from our fee to make this deal go. That's another option.
Yeah.
But I mean,
Not
like
gonna
you
be
say,
a popular one.
it's not a very popular
Right.
one, but that's a complication that you have with a withholding certificate. And really, a lot of folks don't start it until they get the short sale approval because they don't even know if the short sale is going to be approved.
Sure.
So why spend $1,000 to get a withholding certificate if this short sale is not going to be approved?
Sure.
So those are the challenges with withholding certificate, but that's another exception to the FIRPTA application. The other one is what's called a buyer's certification of residential use. And what that means is that the buyer is going to certify that if it's a property under $300,000, if you're listening or watching, write this down, under $300,000. If it's under $300,000 and you're going to reside in that property for at least 50% of the time during the first 24 months, then you're going to be, the buyer will not be responsible, will not be liable at all for any withholding. And the seller will also not be responsible for any withholding. The other situation is buyer certification of residential use for a reduced exemption. Okay, that's more than $300,000 and under $1 million. Same qualification. The buyer or the buyer's family member, close family member, must reside in that property for 50% of the time during the first 24 months. What happens if the buyer decides during those first 24 months they don't want to reside in that property? They want to leave.
I think it's going to fall back on the buyer, isn't it?
Falls back on the buyer. And the buyer becomes 100% responsible for the 15% that the seller was required to pay.
So that's one of the things I really wanted to talk to you about, because when we're representing buyers, and I gotta believe that in maybe too many cases, people look at that the affidavit and they say, let me just sign it. Hey, you're gonna live in the property anyway, just sign it, it's all good. Not really understanding the fact that they're putting or exposing their buyers to some serious risk. And so we really need to clarify that they need to discuss that with an attorney to make sure they understand exactly what they're getting into. That in essence, the buyer is doing the seller a favor.
Absolutely.
But it's a favor that can come back to haunt the buyer.
Yeah, you want to be very, very cautious as a buyer if you're going to take advantage of that exemption and say you're going to live in that property, or
Right.
your family or your close family member is going to live in that property for 50% of the time, and you had excuse me, and you had no intention of doing that, because it could definitely come back to bite you and be all of a sudden a favor that you did for that seller to help them avoid tax liability can fall on the shoulders of the buyer.
So in real numbers, let's say it goes up to $1 million, so the property's $1 million, the buyer signs that, they're basically putting themselves on the hook for 15% or $150,000.
Well, if it's $300,000 to up to $1 million,
Right.
and you have the same residency qualifications, you're going to live in that property at least 50% of the time for the next 24 months, then your liability is reduced to 10%.
Okay, all right, so only $100,000 are on the hook.
Right.
All right, so this is
If
serious
it's over,
stuff.
if it's over $1 million, then the liability is back to 15. The IRS doesn't care.
And it's still potentially falling back onto the buyer.
Yes, sir.
So this is going to come up where you have a situation where a pretty savvy buyer is going to go ahead and say, you know what, I want to use this as far as leverage in my negotiations, because the risk that they're taking is real.
Yeah, I never thought about it that way.
Yeah, the money that the seller is saving is real, intangible. So if I'm potentially saving you between $100,000 to $150,000 or more, they can use that from a negotiations as far as the price is concerned, right?
Yeah, and you know what? Like I said, I never thought about it that way, but I can tell you something else is that in some of these circumstances, the seller is going to have to come out of pocket. The seller may have to come out of pocket and pay for these for this tax liability, which is really huge.
Well, at the end, it's not, listen, none of us have to love the idea of paying taxes, but we enjoy the freedoms that we have and the things that we have because we pay taxes. And the reality is, what's the government's biggest concern from this? And if someone is a non-resident or a foreign national, that if they decide to just go back to their country, who's ever going to collect that money? And if you and I sell property and we have capital gains, we have to pay taxes on it anyway.
Absolutely.
So it's not like, hey guys, I feel sorry for you because you have to pay taxes. It is what it is. We all have to pay taxes. The tax man cometh. So, but this is a rare scenario where somebody other than the person that's realizing the profit or proceeds is on the hook for that. And that's where the buyer comes in.
Exactly. So what's the bottom line here? And I want to just kind of boil it down to the most important issues that I want you guys to consider. In other words, my takeaway from this. I'm certainly not asking you to be FERPTA experts. I don't need for you to know all the exceptions because it's made very clear, it's made express on the FAR/BAR contract that if you have any questions regarding the application of this statute, that you should consult with an attorney or with a CPA. I want to read that directly because this was a section that was implied but was not included until this new version of the FAR/BAR 5 contract. It says, buyer and seller, this is the end of 10I, buyer and seller advised to seek legal counsel and tax advice regarding their respective rights, obligations, reporting, and withholding requirements pursuant to FERPTA. So it's very important that as an agent, if you have any questions regarding the application of any of the FERPTA guidelines or any exceptions, that you make sure that you're not taking a guess, that you're not speculating or assuming it's going to apply or not. Reach out or recommend to your client that they reach out to a CPA or a law firm like the RCA law firm that can help your client in determining whether or not FERPTA applies. Bottom line, okay? Let's do bottom line here. At the contract signing, when you sign that purchase agreement, as a realtor, as an agent, when you sign that purchase agreement, you need to make sure to determine whether or not FERPTA applies. And if you have any doubt, obviously contact an attorney. Here's my practice tip for you. Make sure that if you're out there and you're using the CRISP contract, that you make sure that your party signed a FERPTA addendum to that contract. Okay? So number one, determine at contract signing if FERPTA applies. If you don't know, contact an attorney. FERPTA impact on short sales. Okay? Here's the bottom line, because a lot of us may be dealing with this. The issue comes down to withholding certificate. If the lender's reluctant to reduce the net by 15% because of the withhold, because they don't want to apply for a withholding certificate, if the buyer won't pay the additional cost of applying for the withholding certificate, then you as an agent need to make a very hard decision. Do I take part of my fee and apply it to allowing this withholding certificate process to go forward? If you don't want to do that, then chances are it's not gonna get done. So that's my takeaway with respect to short sales. And finally, if you have any doubts regarding the applicability of FERPTA, you've got great resources. You can talk to the folks at Xtreme. You can talk to the folks at RCA Law Firm, and you can talk to the folks at New World Title, who are very, very up to speed on the application of FERPTA and any of the exceptions.
Right. And from a broker's perspective, real estate agents out there, when someone is asking you, well, should I sign this? Should I not sign this? Whoa. Listen, at that point, be very careful that you're not stepping over the bounds and starting to practice law. Okay, make sure that you have a resource available or information. Remember, as real estate agents, we're supposed to be the source of the source. If you want to have printed material that you hand them, if you want to refer them to a tax professional, every real estate agent, every office should have a tax professional on their team, legal counsel on their team. In fact, one of my good friends out there, when he says, I need that attorney's information, and then she posted, and then right after she goes, never mind, I see it on the wall. So it works, but go ahead and give them your contact information.
That's right. No, I appreciate that. And obviously the best way to get a hold of us will be by phone, 954-437-9066, 954-437-9066. You can also reach us online at rcialawfirm.com, and you can definitely reach out to us. Set an appointment online. If you have any questions regarding anything that you've heard here today, post it on website, on the Facebook, and just let us know what concerns. I mean, this is an issue, especially down here in South Florida, that comes up a lot, especially now that we have so many foreign investors and foreign nationals that have gobbled up a lot of real estate. They now want to sell that real estate. Right? And if you represent a foreign national that's selling the real estate, you need to make sure that you're up to speed on this.
What about this? What about someone, foreign national, bought the property in the name of an LLC, but the LLC is an American entity? So does it apply to that person because the owner is actually an LLC which is an American entity?
No, I mean, FERTA wouldn't apply because the tax would be charged against the entity that's a U.S. Entity. I mean, when that entity files its tax returns, it would have to indicate on there that it took
So they're covered. They're okay. So if the investment was, and as it usually happens, if it was for investment purposes and they bought it in an LLC, then FERPTA would not apply to them.
Right. When they resell it, it's not going to apply to them because it's a U.S. corporation.
Gotcha. So then what about somebody thinking, wait a minute, it's in my personal name right now, let me transfer title over to an LLC.
Too late.
You want to repeat that?
Why?
Why?
If you're a foreign national and you purchase real estate in the U.S. and then after you purchase it, you transfer it to an LLC. Now, if it we would have to look at where the funds are coming from, and that gets a little more complicated.
Yeah.
But the bottom line is, once you purchase the property, you look at the party that actually purchased the property,
Right.
and then now you're reselling it. Because the moment that you transfer the property in the U.S. from the person to the LLC or from the person to a corporation,
It still applies because you're still transferring it.
yeah, there's a transfer right
There's
there.
a transfer, so when you transfer to the LLC, at that point, it's the same thing. The proceeds aspect of it would apply,
Yeah,
right?
listen, I tell people all the time, there's no way of getting around legal issues. There's only ways to properly address those issues.
What did I say? You don't mess with the IRS.
That's right.
Okay.
They're going to find a way to get that tax from you. That's the bottom line. Unless it's done properly, unless you take advantage of some exceptions that are very clear and the facts are very clear, the IRS is going to find a way to take advantage of that tax.
Okay. So as we start
And
to wrap
penalties,
up, right?
and fines, and all that good stuff.
So it begins at the listing. So as you take the listing, folks, at that point you need to determine whether your seller is a foreign national or not. That's when you need to find out. And when buyers, you are representing a buyer, you can go ahead and use the appropriate rider or addendum to go ahead and protect your buyer in those scenarios, because it must be disclosed. It's not something that people can find out at closing. This is information that must be disclosed from the very beginning. I have a question here that may be more of a tax question than pertains to legal. But at the very beginning, before we lost our signal, so we are actually going to have two parts to the show. We got part one and part two when the signal went down. The question then became, if someone wanted to use funds from their 401k and take the monies out to purchase a home, would there be penalties involved? Is that more of a tax professional question?
Yeah, undoubtedly that's a tax issue, and you'd have to look at whether or not there's any tax liability associated with taking out that money.
Right.
Because you may be taking out that money before 55, so you may be taxed on that. So, but I would definitely look to a tax professional to make a determination on that.
Okay. So one of the things that I just got an idea for another show. So a lot of folks don't realize that if you have a self-directed IRA or a self-directed 401k, funds that are in those accounts can be used to purchase investment properties. And then what happens is the income that's realized, the gains that are realized, are tax deferred. So that could be for another great show that we could have in the future, is how people can take some of these investment funds that may be earning very little right now and take a portion of it, invest it in income properties, because it has investment properties, and then the income that's coming in is just tax deferred to when you decide to pull it out. You should be in a lower tax bracket. So I'm going to set that up.
Yeah, you know what? That's another great show would be to have maybe like either a tax professional or have an investment professional come in and tell you all the different options you have to invest the money that's sitting in your IRA, in your savings account. I mean, how to do it properly so that you can minimize tax liability.
That's cool. And also, folks, next week we're going to do another special show. We have a good friend of ours that are coming in. Phil Stevenson is probably one of the leading authorities in the countries on reverse mortgages. So everyone's heard of reverse mortgages because we all see all the stars on TV advertising it at some point or another. And, obviously it is something that for some people is a wonderful, wonderful resource to have. I believe if you're 62 or older, it can be a wonderful way. But most people think in terms of reverse mortgages as a way of refinancing their existing home and pulling cash out. And of course, we're going to talk about that, but the real reason I'm having Phil on is from a real estate broker perspective. A lot of folks don't realize that you can buy a home using a reverse mortgage, which is an amazing opportunity. So let's say you're 62 or older, you qualified, you can put at least 50% down. Imagine being able to buy a home using a reverse mortgage and have no mortgage payment.
Wow.
That is something worth watching. So of course there's criteria and requirements that pertain to all that, but that's what we're going to cover next week. So let's see here. I have a question. What type of proof is needed to prove you have lived in the house for more than 50% of the time? My client is about to purchase a place for herself, and her son will live there full time. Okay, so.
Right, so, I mean, again, the statute refers to not just you, but also your immediate family members. So if
Right.
you can prove that you or your immediate family members have resided in the property consecutively during the last 24 months for more than 50% of the time, then the exception would apply, and you wouldn't be responsible for FERPTA. So the way that you would prove that, obviously, would be through utilities bills. It would be through driver's license.
What about
it would
homestead?
Be,
homestead?
You know, whether you homestead the property. I mean, anything that shows a continuous residence at the property, because obviously you can't have more than one homestead. So you have to reside at that property.
What
for
about
a
like
period of
pizza
time.
delivery? If you have a record of pizza delivery on a regular basis? No? No.
I don't think that pizza
Hey,
delivery.
there's at least one person out there that said, if I can produce enough receipts from one of the pizza places on a continuing basis,
The light
that
went
should be-
off, right? The light went off over there. Someone watching either this now live or watching it later started thinking pizza. That's it.
Because you know what, you think FERPTA pizza...
Right, because no, the IRS actually, the pizza and the IRS go together.
Oh, sure.
You
You're
know?
working on your taxes long into the evening. What else are you going to eat?
I'm hungry already.
Okay,
So-
yeah. All right, so as you mentioned, so back to life, back to reality. So you have, if it's homestead,
Yeah, if it's
Yeah.
homestead, if you have
Driver's license.
utility bills, generally if you file tax returns, where you filed your taxes, where you're indicating your residence is. I mean, anything official that
Right.
demonstrates your residence at that property will demonstrate that you're residing there continuously. And remember, it's 50% of your time. So
Right.
if you can demonstrate that you have utilities paid for there 50% of the year, at least 6 months, that you've paid utilities, that you've paid FPL, you've paid water, that it's actually being used,
right.
right?
As opposed to-
you got to be very careful with utilities too, because I've seen the IRS use utility bills against you.
Right.
Because you're saying, no, I resided at this property. Look, I've paid my utility bills. Okay, well, they look at utility bills and then they check the utility bills of everyone in that neighborhood to see that whether you're using the same amount of electric and water as everyone else. And if they see that you're using barely anything, then it's clear that all you did was pay the minimum that you're paying for utilities, and you're not living there.
So another question that comes up is, what if you just travel a lot? Okay, is that the same as, they look at it the same way as having a residence someplace else? What if you are living there, but you travel extensively? Does that count against the time that you're supposed to be there?
No, like I said, I mean, it depends on what
Because it's
kind of,
technically your residence.
right. It depends on what kind of proof you can offer
Okay.
to show that you live there. That what they're looking for is permanent residency for at least 50% of your time. So
Right.
if you travel a lot, I mean, I don't know what would qualify as that, but I mean, generally speaking, you come back home
Right, you
for
come
the
back-
weekends,
right.
or after your travel time, you come back home. So that would show you're living there.
Okay.
It's not like you're living there 100% of the time, but living there at least 50% of the time. So generally speaking, people who travel reside somewhere else 50% of the time.
Okay. All right, folks. So if you have any questions for myself or Omar, go ahead and type it in right away, because we're starting to count down the time left on today's show. If you have any real estate needs whatsoever, I will plug in our commercial right now for Xtreme Realty Team. So we're located here in South Florida, where we have professionals all over the state, anything that involves buying, selling, renting, or investing, we would love an opportunity to earn your business. You can reach our offices at 954-530-0211. That's 954-530-0211. Obviously, because of the way we handle the show, we are very much in tune with communication. We believe education is critical to a successful transaction. So my agents are trained to provide the best possible service. We are available to step in at any time and be a resource for our agents. So if you want to speak with me personally, again, Tony Martinez at Xtreme Realty Team, 954-530-0211. Now, last week you mentioned you were running off to a foreclosure hearing. How did everything go over there?
We finished half of the trial, and the rest of the trial is going to be finished in August. So, I mean, in foreclosure trials, a lot of people realize, I think it's like a lot of people think it's like a 5 or 10 minute thing. If it's a complicated foreclosure trial, it could take several days.
Wow.
And in this particular case, we finished half of the trial after the last show, and then we're finishing the rest of it in August. I want to commend you. I want to do something I haven't done before. I want to commend your agents that are working under you. I've had the opportunity now, since we've been working together, to deal with quite a few of your agents.
Right.
And it's really been a pleasure, and it's been a breath of fresh air to deal with agents who are up to speed on contract language, who are up to speed on what the responsibilities are as professionals for their clients. And not only that, but they realize that there comes a time when you have to turn to legal professionals. And that's the best advice that you can give to your clients sometimes. And a lot of agents out there want to wear, a real estate agent hat and a CPA hat and an attorney hat, and they feel that by doing that, they're giving a better service to their client because their client doesn't have to pay for a CPA or for an attorney. But what you espouse all the time is, listen, let the people who are the professionals that are well knowledgeable in that field do their work. And if you feel you need to refer someone out, do it. And I see a lot of your agents that are coming to me and saying, listen, even when they have any doubt, they're coming to me and they're saying, I have this issue in my contract. What can you help me with? What suggestions do you have? Because they know that in providing advice that's backed by a law firm that's been doing this for 22 years, they're going to provide a better service to their clients. So kudos to you and to your team for always realizing that it's important to provide their clients with the very best service possible.
Thank you very much, sir. And in winding down, I had a question that was asked of me off air once, and that is, the agent said, do modifications even happen in this day and age? Because, anyone that's going through a difficult time making their mortgage payments, one of the first things that I was always trained to do is look for a way to help people stay in their home. Look, as a real estate agent, we make absolutely zero money keeping someone in their home. As a real estate agent, we're not even allowed to legally charge anyone to help them with a modification. You must have a mortgage license, right? So, but I've always been trained, and I train, look, do the right thing. The right thing is make sure that they've explored all options to be able to stay in their home. And that's where a modification could be a viable thing. Do you see, you're in this business every day. My feeling has always been that a lot of people believe that they are able to modify the loan, but are really not. My joke has been, if you want a mod, an MOD, you need a JOB.
Right.
And I don't think I'm far off from that. The bank, in order for you to qualify to be able to stay in that home, they're not going to, in their minds, make the same mistake twice.
Absolutely.
You have to be able to qualify. But this is a business you guys do every day. Is it working? Is that something that someone should at least look into before they just let the bank take the house, or even do a short sale?
Listen, Tony, one of the things that I pride myself on, and I pride my staff, I'm very, very happy, and I'm very happy with the staff that we have, who's very dedicated to our principal foundation of this firm, which is saving families one home at a time. There's a lot of law firms out there that will take the client's case and they'll just continue to litigate that case as long as they can take. In other words, as long as they can ride that gravy train, and then basically the train falls off the tracks, and the family loses their home, and their stuff gets put out into the curb, and that family gets disbanded, gets displaced. That's the worst thing that could happen.
Absolutely.
So I think that as attorneys and as professionals, we can't look at the day-to-day. We have to look at what our end game is. We have to look at what our strategy is as we get there, but we have to come up with what we want to accomplish for that person. The best way to find out is asking that person, what do you want to see happen here?
Yeah.
Do you want a modification? Do you want a short sale? Do you want to get rid of this property? Do you want not to be responsible for a mortgage anymore? You just want to pay rent. So we need to know what that client wants. And that's the first thing we find out. So we need to know exactly what their goal is, and then we help them achieve that goal. And if their goal is to keep their home, you bet that we're going to do everything in our power to help them keep that home. We're going to file a modification. If they get denied for a modification, we're going to appeal the modification. We're going to appeal it again. And we're going to keep appealing. We've done that 3 or 4 times until the bank either gets tired of us or says, oh, okay, we may have made a mistake in the calculation of that income. Now they qualify. So the answer to your question is, yeah, modifications are still happening.
Okay.
And we're very privileged to be able to offer modifications to folks that hire our firm for legal services. So we offer modifications as an added benefit.
So you can hold off you're actually doing a dual role.
Exactly.
You're doing foreclosure defense because you're applying your skills and your resources to doing everything possible to postpone the actual foreclosure while you're working on the modification. Now, question, is dual tracking, that's illegal now, right?
What's illegal and what's discouraged now is that a bank cannot send you a notification of trying to work with you pre-foreclosure.
Okay.
Pre-foreclosure. So the bank can't send you the notification and say, hey, we'd like to work something out with you. Here's your options. And then at the same time pound you with a foreclosure.
That's the dual tracking.
Right. The dual tracking is more referred to the pre-foreclosure situation where a bank says, I'm going to, let's work on keeping you in your home, and they don't really want to keep you in your home.
Gotcha, which is very different from once the foreclosure process has actually started with the courts. Even though you are engaged in the modification, the fact that you've engaged in the modification doesn't stop the process on the other end.
That's correct, and
Okay.
even if you're in the middle of a modification and you've got a foreclosure trial coming up, the judge doesn't care that you are under a DOJ standard, a Department of Justice hold on the loan because it's being considered for modification. The judge doesn't care. What the judge cares about is making sure these loans go all the way through, or these lawsuits go all the way through to a final conclusion so they can get it off their docket. That's all they care about. For the bank standpoint, pre-foreclosure, they cannot say, let's work out on some loss mitigation options and at the same time start a foreclosure, especially if you show some interest in working with the bank in keeping your home.
Okay, see, so that's something I wasn't aware of. So it's all pre-foreclosure, but once you are formally in the foreclosure process, the complaint has been filed, the les pendens has been issued. At that point, even if you're entertaining or engaging in a modification, make sure you have the foreclosure defense side of it engaged as well.
Right.
Because it's obviously you're running between the two. You're back and
That's
forth.
absolutely critical. I've seen many circumstances where clients are in the process of getting a mod, they've submitted their documents, the bank is telling them, yeah, this looks good, and the foreclosure is going on in the background.
Yeah.
And the attorneys for the bank are really clueless as to what's happening with the modification.
Sure.
And they'll proceed. It's basically like a moving freight train.
Yeah, that's critical because you may hire someone to help you with the modification and you don't have someone engaged to help you in the foreclosure defense. So as you are progressing or hopefully progressing with the modification, next thing you know, you have a sale date on your property because no one's been fighting on that end as well.
Yeah, or the sale has already taken place and a
Yeah,
certificate of title issues and it's no longer your property, so you're out the possibility of getting a modification.
It happens. It does happen. So just to clarify too, as good as you are, and you're one of the best, if not the best, you can't work miracles. And you're not successful every single time.
That's right.
Okay.
I'm humbled by that, by the way.
Okay.
Appreciate that. But I always tell
people want to. Sometimes they hear what they want to hear,
yeah.
and they feel that okay, I've hired an attorney, so I have nothing to worry about. My modification is going to happen. You can only work with what you have.
Yeah, and there's certainly no guarantee in any given case because everyone's financials, everyone's application for modification, everyone's case is different.
Right.
The facts of every case are different. You may have great facts in your case, which may allow us to completely attack the validity of the mortgage altogether. And you may have facts in your case where the loan was completely clean. There's nothing to defend. And we have to try to get that modification done. So we need to make sure that your financials look good. And unfortunately, it's kind of like, you get that one shot to make a first impression.
Yep.
So if you submit financials and you submit documents to the bank that don't make any sense, that are going to absolutely lead to a no answer for modification, you can't take that back.
Yeah.
The bank already has it in their database. So when you resubmit, when you come to a law firm and resubmit, and they see what they already have there, they're going, wait a second, how did you go from making this to making that?
Right.
And how did you go from spending this to spending that? And how come you now have 2 more people living in your house? So you got to be very, very cautious about what you submit to the bank because it's part of your record.
And also, when you do engage the services of someone like Omar, you have to put all your cards on the table. He can't help you if you're not fully disclosing your situation. That's one of the things we run into when we're attempting to do a short sale from someone. And I understand people have been burned, people have been, who knows how much money they've been taken for a ride for, and I get it. But as I try to train all of my agents, if you can't get that person to open up and share everything that's going on and fully disclose their income, their assets, all these things, folks, you only get the first shot. If the bank finds out that something was being withheld, assets, income, savings, any of these things like that, you can kiss that goodbye.
Yeah, you completely lose all credibility in the eyes of that underwriter for the bank, and it doesn't matter how many times you submit the application, it's always going to be a no.
Yeah.
Because you have now burned that person.
Sure.
And they'll take it very seriously.
Right. And in conclusion, on the modification side, understand something because I get it. If you're not in this business every single day, you have a particular perception. The perception might be the bank must work with me. No.
Nope.
The bank must do this. No. In fact, you know what the bank must do? According to the law, they must foreclose. The fact that you signed a contract and they are servicing the loan for an investor, be it the government or a private individual, when you are in default, they must foreclose. They have a legal responsibility to recover those funds for that investor. So if there's anything that they must do, is foreclose on you.
Yeah, a lot of people believe they're entitled
Yeah.
to get a modification. They're entitled
To a short sale.
to a short sale. They're entitled to get a smaller mortgage payment every month than they were paying before. No. You are entitled to the parties abiding by the terms of the mortgage agreement that you signed when you got the money from the bank. And you are entitled to having your loan modification application reviewed.
There you go.
So the bank has to review you for modification, has to review you for short sale. They don't have to approve you, but they do have to review you. And if you submit an application to them, they'll look at it. And I've had denials right away because it's someone that on their own has submitted 8 modification applications. And they've been denied. And every application has different numbers. So the bank already knows that they're dealing with someone that's not necessarily credible. So it's very important, folks, that if you have someone, if you have a client that's interested in a modification, that's interested in a short sale, that you put them in contact with either the folks at Xtreme Realty or the folks at our CL law firm, and we can work with them through this process so that we can give them the best shot. We can't guarantee you a modification, we can't guarantee you a short sale approval, but we can guarantee you the best shot of getting that loss mitigation option.
Even though that, the situation in our country has improved, our economy has improved, the number of foreclosures are down, we still have a situation where Florida is maybe number 6, number 7 in the state. In the country. And one foreclosure is too much as far as I'm concerned. So you may be watching this show and it doesn't apply to you whatsoever because you're in a blessed position. You own your home outright, you're current on your mortgage, but almost everyone knows of someone that is hurting. That's going to come out. It's going to come out at a family gathering. It's going to come out at a party. You're going to hear it through the grapevine. And what if you just sharing this information with them prompts them to take some action. As a result of that action, they're able to get a modification.
Mm-hmm.
What if we can't help them stay in the home? Because you can't always do that. But what if we're able to help them do a short sale and they're able to exit that very difficult situation with at least some dignity and with the least amount of negative consequences against their future? You know what? It's all worth it. If just one person is helped as a result of this exchange, it's worth it. So folks, as we go ahead and wind down the show, again, we ask for your continued support to not only watch the show live when you can, but share it. The vast majority of our views come after the fact. We know that people are busy with their lives. You can't always sit down and watch the show live, but share it. Get it out there. Put it in groups of community groups and professional groups that you think people would benefit. Because again, we believe that we are bringing something of value. We try to have fun with this.
Sure.
Of course, we're doing this from a commercial standpoint. Omar wants to feed his family and provide for the families of his employees. So do we at Xtreme Realty Team. So of course, we love an opportunity to earn your business. But we do feel that we're bringing a much needed dose of education and consumer awareness to an industry that truly needs it. So one more time, Omar, how can they get a hold of you?
Best way to get a hold of me is contact us by phone. Our office is in Miramar, 954-437-9066, 954-437-9066. When you call, the phone will be answered right here.
There you go.
By our lovely receptionist who will guide you and tell you exactly when our next appointment's going to be. Our appointments are face-to-face. I love meeting my clients. I love talking to them about how I can solve their situations. That's what it's all about. You can also reach us online at www.arcialawfirm.com, and I look forward to any questions you may have, which will make you a better professional and will help you help your clients a little bit more.
Okay, just a program note. Next week, a week from today at noon, we're going to cover reverse mortgages, both the refinance side and also the reverse mortgage to purchase program. Once again, we want to thank our sponsors, New World Title. We want to thank you, and if you have any real estate related questions, contact Xtreme Realty Team 954-530-0211. We'll catch you next week. Thanks everyone. Take care.